One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Today we're talking about purchasing real property with solar panel leases and liens. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook. You can find us on X, formerly known as Twitter. At all of those locations, you can find us at the handle @InRem Podcast. That is @InRem Podcast. Also, you can download an audio version of the podcast. You can find that on places like Spotify or Apple Podcasts. Go there, download it, leave us a review. We'd really appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is a follow-up on the last two legal updates in which I was talking about agreements for sale, contracts for deed, land contracts, land installment contracts, whatever your state calls it. It's basically the acquisition of interest in real estate without the title to the real estate transferring. So you basically acquire all rights to the property, including the right and ability to repair, maintain, improve, to pay property taxes, to pay HOA dues, to acquire insurance. Basically, you obtain full ownership of the property, except the deed remains in the seller's name until you fully perform under the contract, at which point then the deed goes into the purchaser's name. So this is a great vehicle to acquire property subject to existing loans. Technically, the due on sale clause could still be triggered, but in my experience, there's less of a risk if you use this vehicle. However, one of the downsides to using this vehicle is, and this is the topic for today, is acquiring or obtaining financing secured by the real estate when you are a purchaser under an agreement for sale. And too often we've seen situations in our office that we have to really just unwind the transaction and figure out another way, where basically a purchaser under an agreement for sale executes a promissory note in favor of a subsequent lender, and then executes a deed of trust or a mortgage in favor of that lender and records it against the real estate. You can't do that. That's not an enforceable document at that point, because the purchaser does not have fee title to the property. They don't have a deeded interest in the property, so they have no ability to mortgage that property or to put that property in trust under a deed of trust. That's just outside of their authority as a purchaser under an agreement for sale or contract for deed. Now, that's not to say that there's other ways to go about this process. It's just if you acquire an interest in the property via an agreement for sale, a contract for deed, and you all of a sudden now want to go and make improvements to that property. So you're going to go obtain a hard money loan, and you want to figure out how is this going to be secured by the real estate. A note with a mortgage and deed of trust is not the right way to do it. However, there's two ways that can be done. It's a lot more complicated than this and requires additional or other types of agreements. But the first way to do it is to do a note. So you always have a note. So do a promissory note, which is your evidence of the loan that's being made. And so you do a note. But instead of securing the note by the actual real estate, you're going to secure the note by the agreement for sale itself. So you're going to then give the lender a security interest, which basically provides that if you don't perform, then the lender can take your agreement for sale and sell your purchaser interest in the agreement for sale, and either purchase it themselves through a bid, their own bid, or they can sell it to a third party, and that third party pays them, and then that third party takes over the agreement for sale as a purchaser. You have to review the agreement for sale to make sure it has the right language. My form agreement for sale always allows for it to be assignable and assumable, and so you wouldn't have any problems with if you have that magic language in there doing a transaction that way. The other option, and you have to make sure that you've structured your LLC correctly, but another way to go about that is to do a promissory note. And if you have a single asset LLC or a single purpose LLC, which means you formed an LLC for the sole purpose of holding that agreement for sale, then you can do a promissory note between whatever person or entity owns the LLC and the lender, and then you would secure their interest by the ownership of the LLC. So what would happen in that case is if there's a default, then that lender could go and sell the membership interest in the LLC that is the purchaser under the agreement for sale. And then assuming they purchase it at the sale, then they step right in and they then will own the full membership interest or be the full 100% owner of the LLC that is the purchaser under the agreement for sale. So basically the agreement for sale and all rights to the property then become theirs in that case. So it's more complicated, and that is one of the downsides of an agreement for sale, contract for deed, land contract, as opposed to your traditional wrap transaction where the warranty deed is actually conveyed. But you can obtain financing. You just have to structure it a little bit differently.
All right. Thank you, Sean. With that, a few announcements for you, the listener. Today at 3 p.m. and every Tuesday at 3 o'clock p.m. Arizona time, we have the Creative Finance Collective. What is the collective? That is a collection or a group of professionals within the space of creative finance, mostly lawyers throughout the country. We get together, we talk about all things creative finance. We talk about what lawyers are seeing in a variety of different jurisdictions, how the law is being applied in the area of creative finance, what different professionals are doing in the space to improve their forms, to handle situations maybe that they've seen come up. It's a chance for us to really just kind of go through, make our own practice better. But the biggest thing that we do for you, the listener, is we make ourselves available. That is the entirety of the collective to you, the listener, we for the entire hour. So if you have questions, we're there to answer questions about creative finance. So again, that's 3 p.m. Arizona time. Come, and we stay as long as we get questions. And if we stop getting questions, we end when we're done discussing with each other. So the more questions we have, the more interaction we have from you, the listener, the better it makes the space, and the longer that we stick around and are there to help you. We've had a lot of lively discussions and look forward to more questions. So make sure to be there again, 3 o'clock Arizona time. You can find it on YouTube, Facebook, as well as Twitter, now known as X. So join us. Be happy to go and answer those questions. Also, today we're taking any questions in the final 15 minutes of the episode. If you have any, make sure to post them in the chat. We'll be monitoring the chat. You don't have to wait till the final 15 minutes to post it. As you think about it, or as we're discussing the substantive topic here during the discussion and it comes to mind, go ahead and post it and we'll catch it and we'll address those questions. With that, we're going to get into our topic today, which is purchasing real property with solar panel leases and liens. That can happen a variety of different ways. And we're going to get into those and get into the problems that it creates and what you do to deal with it. And with us here to discuss that is Sean Clemmensen. Sean, thanks so much for joining us.
Thanks for having me.
Yeah. So President and General Counsel of Tiago Title. You're also a member and head of your law firm. Tell us about your practice, those companies, and what you do.
Absolutely. Thanks again, guys, for having me again on the show. So my law firm specializes in real estate and corporate law. Been at it about 15 years now. I also have Tiago Title. It's a Texas-based title company specializing in residential and commercial transactions. We have a very good number of investor clients that we work with in the typical space and in the creative finance, subject to wrap transactions that we're blessed to call clients. So a little bit about me and looking forward to talking about the topic today.
Yeah, so we're excited to have you, and we know this is kind of an interesting topic from the perspective of lawyers, because we like to solve problems that liens create, and we'll get into what I mean by that. But I think it's also kind of a popular hot topic for the non-lawyer, the homeowner, because of course solar leases is the thing we're told to go do. It's a thing that we're kind of told to go do to be a good citizen, save on it, reduce our power usage, so on and so forth, utilize the sun. So everybody goes and gets solar panels for their homes. And there's a variety of different ways to go about purchasing those, and how you go about that can impact essentially the future sale, the future purchase of your home. So let's talk about, just to kind of lay the groundwork, Sean, what are the variety of different ways you typically see homeowners purchase solar panel leases? There's really only a few, but why don't we go through those to kind of set the table?
Yeah, absolutely. I mean, there's really three ways that you'll see homeowners get involved with the solar panels. It's an outright purchase, which is extremely rare. It is a purchase with financing involved, or it's a lease. The latter two being by far and away the most common. I think in 10 years or more, I've maybe seen one person purchase solar panels outright, because it's a lot of upfront capital. So you end up seeing financing or a lease a majority of the time.
So beyond that, let's talk about the transactionally what that looks like. Obviously, if you're buying an asset in cash, like you mentioned, it's the rarer occurrence just because of the raw cost of what it costs to buy solar panels. Usually pretty expensive. A lot of folks maybe don't have the available cash to be able to do that. But if you can do that, that's of course the cleanest way to do it. Sure. If you can't do that and you're making payments over time, we now have the issue of you've got an expensive asset that we provided to either on lease or by finance. And if we don't do anything beyond just an agreement, all we have is the right to come after you for your non-payment. And of course, the lender or the company providing the solar panels doesn't want that. They want the ability to grab back the asset. So what, in a lease and a financing, what are the kind of the traditional transactional documents that a homeowner would expect to sign that would make up their ability to grab those assets back?
Yeah, I mean, you're going to see a security agreement. So you'll see a security agreement, a loan agreement that's signed, executed by the homeowner. And then you'll see what the corresponding UCC, or Uniform Commercial Code, filing in Texas at both the state level and in the county where the property is located, in an attempt to perfect that lien in the personal property, thus enabling them to have the repossessory interest. And so you'll see security documents, security agreements. I have not admittedly seen every single security agreement with every single solar panel company, but I have seen Solar City, or owned by Tesla. I've seen their agreement, and that's the most common form of agreement. It's a security agreement followed by a UCC filing.
Now, Sean, you mentioned filing UCCs in two different places. So help me out here. So if I file a UCC with the state, I understand that is basically how I secure any interest in personal property, is filing with the state. But then you mentioned the county. I thought you can only record things in the county if you're claiming a real estate or a real property interest by that recording. I thought those two were separate. Why would one of these solar panel companies file or record within the county as well?
As to create it's a fixture filing, right? So the argument that it being a fixture, and thus it's attached to the property, for one, and two, putting the public on notice, or any subsequent purchaser, that maybe purchases it subject to, and then now you've got this, the public's been put on notice that there's a UCC filing that would thus enable that creditor or the solar panel company the ability to come out and repossess the solar panels. And to do that, you need to file it in the property records and put the public on notice. And so that's the intent behind doing it. I also think a lot of times solar panel companies just want to cloud the title, so to speak, to cause title insurance companies to reach out and say, how much are you owed today if we have to pay?
So when you say fixture filing, by recording that in the county, would the solar panel companies in theory, obviously we don't know why they're doing it, but in theory, when you do a fixture filing, that's because you're saying, I have this piece of personal property that's actually becoming attached to and part of the real estate, right?
Yep. I mean, that's the intent behind the fixture filing, is to have it be sort of perfected, so to speak, and to be considered real property instead of just personal. It's really got to pick one of the two, one or the other, but that's a battle that attorneys end up fighting with solar panel companies all the time. And the dynamic between what an attorney understands the law to be and then a title company and what their position is going to be when somebody tries to sell the property.
Yeah, and we know this can pop up, obviously, in the world of creative finance.
Yeah.
That brings a new element. But one of the areas where you saw this pop up early on was with just homeowners that entered into these agreements that decided to go sell.
Mm-hmm.
And when they went to go sell the property, they realized, well, that wasn't the only thing everybody had to come to terms on, that there was this other, whether it be lease or financing agreement that's out there lingering, that's either clouding the real estate title or, or is going to require the assumption of the new homeowner, can really kind of muck up some of these deals and require an extra layer. What would you say for homeowners that just, the liens aside, what they should prepare for if they do enter into these agreements in terms of what it's going to look like if they try to later go sell the property?
You absolutely have to read the documents. I mean, I support the intent and the purpose behind solar panel companies and renewable energy. I don't support how they're done. I don't support the agreements that are just sort of shoved in front of a homeowner's face who never reads them and doesn't understand that if you sign a 30-year lease or a 15-year lease or a 25-year loan and you're in year 2 and you want to sell it, now you're at the mercy of the solar panel company. It's got to be addressed. You either have to pay it off, you have to try to get the solar panel company to exercise self-help and remove those solar panels, which they're not going to do, or you have to try to get a homeowner, a buyer, to assume the loan, which again, you're at the mercy of the solar panel company. So it's so critically important to read this documentation when the guy or girl shows up on your doorstep and says, I'm going to save you $150 a month on your electric. What exactly are you signing? Because unless you plan to stay in the house for the entirety of the lease or the purchase or the financing, then it's going to have an impact on you at some point in time. And the average homeowner only lives in a property 5 to 7 years, right? So we know that you're going to have to address it at some point.
So in your experience, what do these leases or financing agreements state as far as assumptions and the ability of a new buyer to step in and assume?
Asking me that, my answer now is different than it was 4 years ago. And in fact, I just reviewed an agreement last week on the solar panels, and it made very clear in the document that they signed itself that this will not be and does not have to be assumed whatsoever. 4 years ago, 5 years ago, there was assumptions of solar panel leases were more common. I wouldn't say that they happened all the time, but they were certainly more common than they are today. I've seen solar panel companies, especially when we've gotten into the creative financing, just flat out deny any sort of assumption and say, nope, sorry, we're not doing it. You've got to pay it off. And it's blown up a lot of deals, a lot of transactions that we've been a part of.
Now let's say hypothetically, and I know this isn't happening anymore, but the owner's like, look, I got to sell my property. This is holding up the sale because the new buyer, isn't going to want to take it subject to and whatever. They're more conservative, traditional, like we either assume it or those panels are gone, right? Mm-hmm. And the homeowner that's selling it goes to the solar company like, hey, I'm done. I'm selling. Come get these panels off my roof. And the solar company shows up and actually takes them off and does what they're supposed to do by law, make the roof, watertight and put it back together again. And like they never existed. But does that mean though, that the original borrower or tenant is off the hook financially at that point?
Yeah. I mean, if the solar panel company comes out, removes them or repossesses the solar panels, and in turn then files a UCC3 and terminates the agreement itself, then yeah, you would be off the hook as the seller should they be removed. But the frequency with which solar panel companies are doing that these days, it just doesn't exist anymore because they're just saying, no, I'm not coming to come get them. Or if they do say I will come get them, what used to be $1,000 fee or $1,200 fee to have them come remove them 4 or 5 years ago is now, I just saw one last week that was like $9,300, which is just insanity to me. But yes, if they come remove them, then in theory, there's no more obligation on behalf of the homeowner.
But they're not going to do it free of charge. They're basically telling the homeowner, not only do we get our solar panels back that we can then put on another roof at some future time, but we want something from you financially, right? And in the most recent case, $9,300.
Yeah, and it just doesn't stop there either, too, because if you think about this, as you guys know, if I go under contract as a seller with a buyer, right, and then the solar panel company comes out and takes off those solar panels, I got to put the property back into the condition it was at the time the contract was executed. So am I trusting that the solar panel company is going to repair the roof? No, I'm probably going to go hire a roofer and have them come out after the solar panel company leaves, pay whatever that cost is to put the roof back into the position it was at the time the contract was executed. So there's just a lot more cost that's associated with getting the solar panel company to remove them outside of just what the solar panel company charges.
Now, Sean, within the realm, we were kind of talking about traditional purchase agreements within the realm of creative finance, where you've got a buyer and a seller, or a seller willing to sell and a buyer willing to buy subject to existing loans. And they may be willing to do it subject to the existing lease or financing agreement with the solar company. Do the typical financing or leasing agreements with the solar company have like the equivalent of a due on sale clause that a note might have, whereas the buyer has some risks that they could call that due if they decided to just do the transaction without telling them?
Yeah, they do. I mean, at least the ones that I've seen, the larger solar panel companies do in their security agreements. And so it would be just a textbook default under the security agreement themselves, allowing the solar panel company to come out and repossess the solar panels. So it's absolutely a concern that when I get consulted by investors that are wanting to purchase properties with solar panels, or, I mean, look, HVACs or anything else that's a subject of a UCC, that we have to discuss. And some investors say, I don't want to go down that path. I don't want the roof destroyed. I don't want the HVAC taken just for lack of payment, and they'll move on to another deal.
So how are these liens handled in the traditional escrow process? I imagine that most of these issues are discovered during the escrow process because maybe the agreements are old enough to where most homeowners enter into it, not even think it's going to be an issue, and they're just going to be able to sell it. And this comes in and plays out. But are these usually getting negotiated, if at all, within that escrow period?
They usually are. I mean, and I will say that the sellers that know that they have these solar panels on and that there was some sort of UCC filing, that they or their agent will negotiate or mention it to prospective buyers beforehand, and then have that addressed before it goes under contract and under escrow. But most of the time, these sellers don't know that. So when it comes into Tiago Title or any title company, we examine title, we see that UCC, in which case we then have to address it with the seller, get the contact information, reach out, get what their options are, let the homeowner know what their options are, and ultimately they have to pick, which option, what's the lesser of the evils that they want to pick there.
So here in Arizona, we use the Arizona Association of Realtors forms. If you're a realtor for generally a traditional sale, then you have the right to use the AAR forms. And AAR actually put together a solar panel addendum, that addresses all of this, and gives, the different options as to what it would look like to close with these panels on the house, and, different options, assumption, and, subject to, and all that. I know in Texas, you guys have TREC forms. I think you do have realtor forms. Is there addendums in Texas that can be used to deal with these solar panels that exist at the time of sale?
There is a TREC form, for those that don't know, the Texas Real Estate Commission, called the Addendum Regarding Fixture Leases. And you can, so what addendum, you can pull it up, you talk about, and then paragraph 1, you identify whether if it's a leased fixture, right, not a finance, if it's a leased solar panel, you can check whether the buyer wants to assume it. And you can actually check whether it's a solar panel or a propane tank lease. I don't know if you guys have that in Arizona. Propane tanks probably do. Water softeners, Social Security leases. You can check whichever one it is, and the buyer can then elect to assume the lease or not assume the lease. So there is an addendum for it, and it was just created within the last year.
So, Sean, jumping back into the kind of the creative finance realm, and understanding some of the risks that could be associated with, if you're dealing with, sounds like a lot of the newer agreements with solar companies are either not providing an automatic ability to assume the agreement, but are essentially calling it due. Let's talk about some of the risks here. I mean, anybody in creative finance should already be approaching it with the idea that they should be comfortable with some level of risk, right? Because you're already dealing that with a lender. Now you might be dealing with that same level of risk with the solar panel company. Assuming that, I guess the first risk, which you mentioned, is that they likely have the ability to call that loan due if you transfer it. What in that case are the solar panel company's remedies?
You cannot prejudice the real property. So usually their remedy would be, and they have, is to come out and repossess the solar panels. Take them off the house or the HVAC or the, whatever it is that's the UCC. But they'll come out and they'll remove them, and they don't have to put the property. They don't have to put the property back into the pristine condition it may have been at the time when that occurs. So they can just come out, rip the solar panels off, and a lot of times you'll find damage to the roofs and things of that nature. So I would tell investors, if you're purchasing a property subject to a solar panel lease, you need to factor in what that cost would look like in the event that they repossess, one, and two, you need to factor in what your exit strategy is going to be as an investor. And I think that sometimes investors just go in with the intro strategy. Well, how can I get this property? But what are you going to do 2 years down the road? Are you going to wrap this? Is this solar panel lease going to always show as an exception? Is it going to be an exception on the deed? How do you plan to get out of this solar panel lease? Because it's not just going to go away in the event that unless the solar panel company comes out and repossesses it. So what is your exit strategy as an investor? Because it's going to stick around until they do something about it.
So like a standard subject to transaction where the buyer agrees to basically perform the borrower's obligations, assuming with a solar panel lease or loan, the buyers and the seller agree that the buyer is going to make those payments. Have you found that these solar panel companies will accept the payment, and so long as the payments are being made, they're happy? Or
they've been rejecting. It's funny you mentioned that. I mean, they've been rejecting payments.
Oh, wow.
And we've seen it happen. They're just, we don't know who this is. We're going to reject the payment. They just won't take the payment, which is surprising to me, because if I was getting paid, I'd just take the payment. I mean, presumably, why do they want the solar panels once they're on the house? They're not worth anything.
Right.
But no, they've been rejecting the payments from what I've seen more often than not. So, but as attorneys, we often get called when it's worst case, not when we hear the best case. So I may not hear as often how often they accept the payments.
Well, so one of the remedies is to come, and we've been talking a lot about coming and taking the panels off. But what if they decide, hey, these panels are scrap metal, they're really not worth anything. I'm assuming that their agreements have other remedies available, which includes filing a lawsuit against the original owner, / borrower tenant under the lease. Is this something that is available to them if there's been a conveyance of the property without their permission and approval?
It is available to them. I haven't seen it happen.
Okay.
That's not to say that it doesn't happen, but I have not seen that happen. I can imagine, and I think for a lot of solar panel companies, there's a practical side of this, which is what are we really going to get out of it? What type of, if we get some sort of monetary remedy, what is that going to look like? Are we ever going to collect on it? So I think there is that type, the practical side, believe it or not, with solar panel companies, as it comes up. I have not seen that happen very often, where they turn around and sue the obligor on the underlying, debt.
And even if they were, and there were some assets out there, I'm assuming that this is a debt that would be dischargeable in a bankruptcy proceeding.
Yeah, I mean, you got the bankruptcy proceeding, and not to mention, I mean, we have our sacred homestead here in Texas. We just love to death, right? And it's very difficult to go collect against anything. And most people don't have a ton of investment properties, especially in creative finance. They don't own multiple properties, at least the seller does. And so what are you going to get against somebody that doesn't really own anything? Are you going to go try to garnish their wages? I mean, you're going to try to get a receiver appointed? Probably not.
Well, let's talk about an investor who has, consulted with you, and they're like, okay, I get it. I know the risks. I know that these can be taken off. And like you said, generally an investor going in has some form of exit strategy, right? They're not going to just hold the property and pay the mortgage and be like, oh, I have a vacant house, good for me. Like, great investment. So they're going to do something, right? They're going to either lease the property, or they're going to, rewrap the property, do an agreement for sale, whatever the case may be. They're going to do something with it. And that brings in now a whole another third party where you have these solar panels on here. What would be your advice to an investor who says, okay, I get it. I know the risk, Sean, I'm going to go forward. But on the dispo side of things, what would be your advice as far as the proper disclosures and things like that to be made to, because obviously a tenant going in thinks they're going to have a $0 electric bill only to find the company pulling the, solar panels off the roof. What's your advice there?
It's, as we all say, disclose. I mean, you cannot disclose enough to, certainly on the buy side, if you're selling to a what's going to end up being a consumer's homestead, you absolutely have to disclose there's an existing solar panel lease on there. I have a number of disclosures I've written that I send to investors that they can include as part of their contract. So you have to disclose it. Frankly, I'm not a huge fan of as an investor purchasing a property with a solar panel lease and not addressing it prior to the dispo side. Because I just think it subjects you to lawsuits. No matter how great, as you guys know, disclosures can be, when you got a consumer, the homestead innocent consumer that's going to buy this, all it takes is for some judge or jury to go, what you were doing, sophisticated investor. We don't care how much you disclosed this to them. They didn't understand what they were doing. And so I am a bigger proponent of addressing the solar panel leases prior to the dispo side to a typical homeowner. My position changes a little bit if you're disposed to another investor, a sophisticated investor that's been doing this. But if it's a homeowner, I do think it should be resolved prior to going under contract, and certainly a number of disclosures. You still need to disclose it to a tenant too. I think the risk is a little bit less to a tenant than it is the homestead end buyer consumer, which is generally how a lot of investors dispo these properties, is to the end consumer.
Well, now you mentioned that you want to see the investor resolve the solar panel issue before they, do a dispo, which is interesting, right? I mean, I know in our practice, we've been able to negotiate pretty good buyouts with these solar companies, depending on the leverage that we had and those types of things. Talk to us about what that would look like as far as, working something out with the solar panel company after an acquisition by an investor.
I don't think it's I mean, I agree with you guys. I don't think it's impossible to do that. I think you can certainly go negotiate with these solar panel companies. I've done it where you can go in and you can negotiate a lower payout. And so I always propose to investors, start having these conversations honestly, in idea with yourself or with your team, and maybe even the solar panel company before you acquire it, to know what that cost is going to look like. Because once you buy it, then in my opinion, the solar panel company's got a much stronger legal position to say, screw you, we're not doing it, right? We're not going to do anything. There's a default here. So we're just going to come after whatever we want to come after. But I don't think it's outside the realm of possibility to negotiate some sort of buyout, because ultimately solar panel companies do want to get paid, especially if they haven't been paid, or maybe the prior owner wasn't making the payments. So negotiating some sort of payoff should be factored in for an investor when you are considering even buying the property. What does that dispo look like? How much is left, right? Go get yourself the payoff on the acquisition side to know what you're dealing with on the actual amount left. I see so many investors just go, we're going to buy it subject to, and I'm like, you're not going to even get like a statement and figure out what is left. And no, it's no big deal. We'll just take over the payments. To me, that doesn't make a whole lot of sense. I want to know what I'm dealing with. But I do think you can negotiate with these companies.
Sean, so if you've worked with investors, and I know you have, especially real estate investors, one of the things they love are distressed properties. And one area where we find distressed properties are in foreclosure or post-foreclosure, post trustee sale of the property, depending on what state that you're in. Maybe it's a judicial foreclosure. In any event, post foreclosure of a senior lien. And why the investors, of course, love that is this idea that foreclosure on a senior lien wipes kind of title clean for any junior liens that are under it. But when we were talking about the solar panel liens, you mentioned UCC1 financing statements, which of course are really personal property liens. We talked about fixture filings, which apply to real estate. If an investor comes in and buys a property at the foreclosure on a senior mortgage lien holder, what confidence do they have? What is the status of the property or the liens that exist on the property post foreclosure?
Well, I mean, my position is that my legal position would be that they're wiped out and they don't survive the foreclosure. But what I believe as an attorney is going to be different than what these national insurance companies are going to do as a practical matter when they're deciding whether or not to insure the property when the investor when the investor goes to resell it. So, and that's we've talked about it before. That's the dynamic between attorneys and title insurance companies. They sometimes go like this because insurance companies are just risk averse by nature. But in my opinion, it wipes it out almost every single time.
So flesh that out. So a title company, when you're getting ready to close, sees that there are existing UCC1 liens. Is that what you're saying? And they're like, well, we see that there's still some type of lien out there, so we're not comfortable to close.
Yeah, and the conversation usually goes like this, at least with even some of my underwriters. It goes like, hey, Sean, we know full well what the law says, right? We know what this says, but we're the one that's going to issue the insurance policy, and this is our position. It has to be addressed. It's got to be released. Okay, right? So if one of your insurance companies, and I'm not going to name any of them by names, says that, then you either got to go find another. We have 3 underwriters we work with, and we might go to a different underwriter that I know is not going to make me go get a release or UCC3 for that the financing statement that was filed, because the law does say that it's effectively been wiped out. So I think that's important as an investor to understand what title companies you're working with and what their positions are on post foreclosures treatment of UCCs. So I mean, I know 2 of our 3 are going to require us to go get a release or termination. One of them's not. So if I see a UCC file post foreclosure, I'm going to send it to the one that doesn't require me to do that, right? And then I don't have, then it's not going to make an issue for the sale. And so I think investors always have to remember that insurance companies are exactly that. They can dictate whatever policy they want because they're the ones issuing the policy, whether it conflicts with the law or not.
So we've represented a number of investors who have purchased properties at foreclosure and on liens senior to any interest the solar company would have. They were installed after the loan that was foreclosed was in place. And the way we've dealt with it, and it's very similar to what you're saying, is we have like a standard letter we send to the solar company basically saying, hey, you're out, because of course the title company looks at it and they go to the solar company and they ask for a payoff. And we're like, we don't want a payoff. We don't need a payoff. They're out. So we write a letter and basically say, hey, look, you don't have a lien against the real estate. You're out. We foreclosed you. And they always respond with this. Oh, no. We don't have a lien against the real estate. We have a personal property lien against the solar panels. Now, we've been able to take that letter to some title companies and say, look, this is a personal property interest. Are you insuring personal property or are you insuring real property? No, we're insuring real property. Okay, then this shouldn't even be an issue, right? What's your take though? Here's what kind of always sticks in my claw. And I haven't had the right of client that would want to pursue this. But
we're still waiting.
We're still waiting. I'm waiting for that one client that's like, oh man, I'm out for blood, type of thing. But for me, my position is, if you have a personal property interest, that's great. Like you have an interest against the solar panels, but don't go and record in the county recorder's office because now you're claiming a real property interest. So either the solar panels remain personal property or they become part of the real estate. And if they become part of the real estate, then in that case, the foreclosure wipes you out and you don't have any interest in those solar panels, not even a personal property lien like you claim. So my thought would be, man, that's a great slander of title claim at some point.
I was just going to say that. I haven't found that client yet either that wants to just hire me to go to all the solar panel companies for a slander of title action, but I would welcome it. I have not had that client either, but to me, it would be a textbook slander of title action. But yeah, I mean, I've sent letters just like you, and I had a solar panel company probably 2 weeks ago, write me back and say, ask me to provide the notices to ensure that the foreclosure was conducted properly. And I had some choice words that I won't repeat on this podcast right now. Like, I don't need to tell you whether the foreclosure was done properly or not. It's not your business. But I've sent similar letters to some of these. And title underwriters, there are certain title underwriters out there that understand that. And aren't going to make you go chase down. I mean, I have one that doesn't even make me send a letter from an attorney like you. It says, "Hey, look, this is wiped out. We're not worried about it." I mean, because like you said, if you're insuring the personal property, we don't care if you come take the solar panels off the property. Why do we care?
Right.
If we're insuring the real property? You don't.
Right.
So,
I'm curious, have you seen or noticed a difference in the favorability of terms in, let's say, financing agreements for solar panels versus leasing, or they just kind of mirror each other and are pretty similar?
To me, at least the agreements I've seen, they're pretty similar. They just disadvantage the homeowner. No, I'm kidding. I mean, the homeowner gets screwed. No, they're similar. I don't, and I've even jokingly said there's no difference between a lease and a financing of it to me, because they treat them the same.
So have you found any successful stories of, in a perfect world, we'd like to think that, well, a homeowner or listener who's listening to this could theoretically understand all their risks and discuss that with the salesperson and the company before it's installed and negotiate terms that are fair to everyone, so on and so forth. But we know how that plays out with a big company that sells something. Their forms are almost never modifiable, or they won't agree to do it, whatever. Have you run into situations where folks have had success in negotiating favorable terms?
I've never heard of it, and I will never admit this. I guess I am now, but like 6 or 7 years ago, I just needed to do my due diligence, and so I attempted to negotiate with a solar panel company on the terms in their agreement themselves. It may have been like 8 years ago, and they wouldn't budge. And I even got up to like senior management. They're like, we just don't modify our forms. So I mean, they wouldn't change one word. And at that point in time, I did it really to understand what these homeowners were going through and how difficult it would be to negotiate with these companies. They just won't do it, in my experience.
So go ahead, Sean.
So have you though seen some success though in say somebody who acquires the property after a foreclosure and it wipes out the real property lien? Have you seen them have any success going to the solar company and saying, hey, look, I'll give you pennies on the dollar and buy you out? And have you seen that kind of come to fruition?
Yeah, and I think, I mean, with anything, and I think it depends on the market. It depends on where certain companies were during 2020 and 2021. I think just in general, some companies were willing to take money more easily because solar panel companies did for a while there take a pretty big hit. And so I did see people negotiate successfully for not pennies on the dollar, but certainly a discount. What would may have been a $25,000 buyout. I've seen them, $7,500, $10,000, right? So paying a fraction of what they were obligated to pay. But I haven't seen that as of recently. And I've just seen the cost just skyrocket. The termination self-help fees have skyrocketed. But I do think there is success, and I don't think you should be afraid as a seller to go negotiate with the solar panel company. And you for sure have to get to the higher up, right? If you're talking to the sales rep, and I don't mean this with any disrespect to the reps, they're not going to be negotiating a buyout for you. That's not how it works.
Now, let's say I'm a purchaser at a trustee sale that's senior to any solar panel interest, and I purchase it. Am I then obligated to write checks every month or to pay some amount to the solar panel company? How does that work as far as my obligations there?
No, I mean, I would argue you're not under any obligation to make those existing payments. I mean, you certainly have to understand as the new owner of the property that if those payments aren't made, that they could exercise their remedies and repossess the properties or the solar panels. So I think if you understand that, it may drive your decision, but there's no monetary obligation or legal obligation to pay the prior owner's solar panels.
And during that time that I'm not writing a check, but the solar panel maybe has the right to repossess, I'm assuming I can just use those solar panels and, have a reduction on my electricity. Like all of a sudden, by my use of them, doesn't make me then obligated to, make payments or anything.
No, I mean, I would agree with that 100%. I don't think you're obligated just because you use them. And I don't know enough about how things work behind the scenes on whether or not whatever energy provider they're with, do they need to be updated? I don't know how that part works because I've never been involved in that part. But I can't imagine there's no legal obligation that you somehow assume the existing obligation from the prior owner just because you use them.
It would seem too that the solar company's last resort is to get the solar panels back. They don't really want the panels back, right?
No, I mean that to me, that's they'll likely, and I've seen it. They would rather take a one lump sum payment than have to come out and rip those solar panels off because of the cost of labor just to go rip those solar panels off. So that's why I do think people can be successful in negotiating a buyout or a payoff with some of these solar panel companies.
So now this gets even a little bit trickier. I've purchased the property at a foreclosure sale.
Mm-hmm.
I've wiped out any type of fixture filing.
Mm-hmm.
And now the solar panel company wants to go and remove those from my roof. Are they allowed to step foot onto the property that I validly own to remove those, or do they need a court order to do it?
That's a good question. You can repossess the solar panels. I don't think you necessarily need a court order to go do it, but you'd be stupid, especially in the state of Texas, to go step on somebody's property without giving them adequate notice that you intend to come onto their property. So that's a tough one. I mean, and I thought you were going somewhere else with it, which would even be if I bought it at the foreclosure sale. Now it's all of a sudden, maybe I do want these solar panels. I don't have a power of attorney. I don't have anything that allows the solar panel company to even talk to me. So how can I even pay them if I wanted to pay them? That's where I thought you may be going with that question, which raises another whole set of issues too. And some solar panel companies, that's why some solar panel companies won't even accept payment because, there's no power of attorney. There's nothing that they can rely on.
Well,
to say, hey, yeah, we'll take this.
yeah, well, and if the law, I guess, is in Texas is like it is in Arizona, you have the right to self-help repossession under a security agreement so long as you don't breach the peace. And of
Yeah.
course, I think the same is true with real estate, but when you foreclose non-judicially or judicially, you're never breaching the peace. You're never going on the property. You're just conducting a sale. Whereas to physically go on the property, to climb up onto a roof, that could, I guess, to the extent is the law in Texas similar that just like repossessing a car, you can't do it if you're breaching the peace.
Yeah, I mean, you wouldn't put them on notice. I'm coming to your house in 30 days to remove the solar panels at 10 a.m., whatever, March 1st. Put them on notice that you intend to come out there. And obviously, I mean, I would never represent a solar panel company, but send it certified mail, get the notice out there and proof that you gave it to them, tape it on the door.
Mm-hmm. Well, then what do you do if the property's walled in completely and it requires, scaling a wall or going through a gate or whatever else, which I guess this just all further illustrates why a solar company, I think, is going to be loath to have to go repossess the panels, right? And
how common are they in Arizona? I mean, is it 1 in 3 homes have solar panels? I mean, it's not super. In the last 2 years, it's become incredibly more common in Texas. I mean, we didn't see solar panels on our house in the last, 3 or 4 years. And now the last 2 years, everybody's got them, it seems like.
Well, based upon the amount of sun that we receive every year, as well as the heat during the summer, solar panels are fairly popular. I mean, here in Arizona, because, the electric bill of a 2,000 square foot home in the middle of the summer is going to be like $500 to $600 a month. So people are really into those solar panels if they can, swing it. But the problem is, like you said before, it's like, yeah, but this is now a very long-term commitment that you're making.
And it's random. I was curious as to what Arizona's like, but I mean, I don't think I've seen anything less than a 15-year finance agreement or security agreement or a lease. And most of the time they're 25 to 30. I mean, I've never seen anything shorter than 15.
Yeah. And that's pretty consistent out here. And what's interesting is those panels are only warranted for like 20 years. So, it's like, oh boy, and it takes like 15 years to break even, if you finance them. So it is it's not for everyone. Not saying that people shouldn't do it. It's just, you better really, really
read it. I mean, it's a business.
Figure it out. Yeah.
At the end of the day, it's a business. And while it is very beneficial, you just have to, it's like with anything, you have to have an expectation. You need to know when you're getting into something, anything, what's going to be what's your expectation of it. And for the average consumer, they have no idea that it's a 30-year commitment. They don't even know that something's filed against their property in theory, right? The UCC, they have no idea that anything's been filed. And it frankly really upsets them. I mean, every time we have to be the bearer of bad news, hey, UCC's filed against your home. They're like, what are you talking about? Mm-hmm. I equate it to the same time when people did loan modifications and they had no idea that HUD would attach a second lien to their home. They're like, what do you mean there's a second lien against my house? It's that same principle, right? Homeowners just don't know, no matter what they sign.
Yeah. And I think what really troubles it is the idea that, some folks used to be used to this idea of maybe a second lien with like a pool, and you'd finance that, and they just knew it went with the sale of the property. Everybody understood that had to get paid off. But this idea that with like solar panels that the solar panel can require the agreement of this new party, and maybe it's to terms that nobody wanted, and that could kind of muck up a sale. I think came as a shock, and rightfully so, to a lot of folks.
I think so too. And it shocks investors too, even the seasoned ones, when they go encounter their first sub 2 property with a solar panels on it.
Well, Sean, thanks so much for joining us. We appreciate it. Tell our listeners how they can find and connect with you.
Yeah, again, thanks for having me today, guys. You can come to any one of my websites. My email address is sean@scjwlaw.com. We got a website. My title company, Tiago TX, has a website. Happy to connect with you guys anytime and field any questions that you have.
All right. Well, it was awesome having you, and let's do it again soon.
Let's do it.
All right.
Thanks,
Sean
Sean.
Clemmensen, everybody. Thanks for joining us. That is our show for this week. Make sure to join us this afternoon for The Collective, and next week, every Tuesday at 10 a.m. Arizona time. We'll see you next week.
Have a good day, everyone.